Hi, everyone. Thank you for joining us today on our third webinar, third time going lucky. Thank you so much for making the time. Apologies for running late. The reason why this is happening is because you've all heard of the security issues with Zoom. So we decided to go for the extra security features, but now we're trying to figure them out. I'm just going to be honest, this is very new for us. But we hope that this is going to be able to protect our webinar and the panelists who are on here. So just by way of introduction, my name is Gichanga, for those of you who are new here, and I am an attorney and the founder of Luma Law. At Luma, we exist because we think law should be simple, should be practical, you should be able to use the law to help yourself out of daily situations that a lot of us can sometimes find ourselves in. And COVID-19 is a good example of how the law and real life intersects, because it affects our salaries, it affects our job security, it affects a lot of things that have real life consequences for our lives. So to check us out, you can go on our Hi Luma Law Facebook page and chat to Luma, where we've actually put together a whole lot of frequently asked questions, just to help people get information that's relevant and that's credible, because there's a lot of misinformation that's already out there. I'm not going to talk too much because we're already running a little bit behind. We're going to try keep it to an hour, but that never always seems to go according to plan. But we really are going to try keep it to an hour because, I mean, data is expensive. For this webinar, it's important for me to say right up front that the information that you get here is not legal advice, it's legal information, because as lawyers, we can't ever give you advice without knowing the whole story or without understanding the other side of the story. So this is just for you to make informed decisions about your life and about the way forward in the situation that you find yourself in. The focus of today's webinar is going to be on retrenchments, on dismissals, and of course on UIF, because they all go hand in hand. We're going to talk a little bit about how to go to the CCMA. If you need to go to CCMA, we're going to talk about how to go to the Department of Labor. And we're also going to touch on how to the whole UIF process if you've been retrenched. Some housekeeping rules. Please, let's respect each other during the webinar. Let's wait until one person finishes speaking and before we interrupt. Please use the raise your hand function on the webinar for you to be able to raise your hand, and then you'll be given a chance. And there's no such thing as a stupid question, so please feel free, because if you don't ask now, when are you going to get another chance to ask? Oh, I just saw now we're live on Facebook. This is the first time we're doing this. So hello world. So for now, let me introduce my guests, my panelists, my partners in crime, or not. I'm going to start with Kgomotso Mokoena, who's an attorney and a lecturer at UJ. Kgomotso's been in the labor law space for over 10 years now. So she really does understand a lot of what is going on and how COVID has impacted a lot of people's employment rights. So she'll be speaking to us a lot about the processes that people have to follow in order for them to be able to enforce some of these rights. And we have Jermaine Mop, who is our resident UIF expert, and he's been in the game now for over 10 years. Jermaine is currently studying towards his master's in labor law, so we're in very, very, very good hands. I've also invited one more panelist. His name is Zweli Mkhalamele, and he's going to speak to us a little bit about how our responsibilities as a result of us not being able to get our monies, how our situations such as paying rent and evictions and how that's going to affect us, because going forward, a lot of people are finding themselves in a very tricky situation when it comes to that. So I'm just going to kick it off with some of the questions, but I think I'll let the panelists introduce themselves in 30 seconds. I'll start with Kgomotso.
That was surprising. Okay. I'm a lecturer at UJ. Yeah, and my primary research focus is labor law.
Thank you, Kgomotso. Jermaine, you're up.
I don't think I need further introduction. She's already did everything I already needed, so I'm here to and available for answer questions. Yeah.
Thank you. Thank you so much, Jermaine. And our newbie is Zweli. Zweli, please say hi to the people.
Hi, everyone. As Grace mentioned, I'm an advocate of the High Court, and I have a serious interest in public interest law litigation. But yeah, Grace has summed it up quite nicely for me.
Thank you, guys. I did not mention he's an advocate, but he is an advocate. So thanks for that, Zweli. Guys, I'm just gonna kick it off. We try and do things really informally here because I mean this is a really heavy topic. A lot of people's lives are affected. I mean, we're talking about people's livelihoods, people's futures, and the way forward. So we do want to keep things casual, as casual as we can. We're gonna do it as a Q&A session. So we're gonna go through a lot of the questions that have already been sent through to us. But you're welcome to use the chat function to send us additional questions, and the Q&A function to also send us additional questions as we go. Kgomotso, I think we're going to start with you because our focus is on retrenchments. If you could just talk us through what are retrenchments and when may employees be retrenched?
Okay, thanks, Grace. So I think what's really important to know, okay, retrenchment is really much more of a colloquial word or an informal word that we use for dismissal for operational requirements. So it's a type of dismissal. You can be dismissed for reasons, misconduct, poor performance. Operational requirements is one type of dismissal. And what does that mean? It means you are dismissed for economic, structural, technological, or similar means or needs, right, of the business. So for example, if it's a technological need, it means they bought a machine that does what you do, and they find it cheaper to run that machine than to pay you every month. So that would be a technological need. Now, economic needs usually relate to the business either not doing well financially or wanting and seeing that they could make better profits or do better financially than they are doing now. And then they might see a need to retrench or dismiss for operating requirements. I think that's really the crux of it.
And like a lot of employers are using COVID as a reason for retrenchment. So a lot of people are getting letters saying that, look, COVID is here, we have to shut down shop, so we're going to have to retrench you. A lot of these people are just getting either letters or SMSs just telling them, don't come back to work, we're not open. Is this how things are supposed to go?
So, okay, no. So that's not the way generally an individual should be dismissed for operational requirements. 19, let me just say from an employer's perspective that COVID-19 might very well be a reason that a business decides to dismiss. It's not that, you know, when a company says we're dismissing for or we're retrenching, they are lying. That's not necessarily what's going on. Speaking, to begin a retrenchment or to kick off a retrenchment process, the employee should be issued with a Section 189 letter that makes reference to Section 189 in the Labor Relations Act. Now, that would be a notice of contemplation of dismissal. So it's not, hey, we're dismissing you today. It's to say, we're thinking of retrenching. The categories of people we're thinking of retrenching. This is the reason we are thinking we need to retrench. We are contemplating retrenchment. That is genuine. That kicks off genuine consultation. So about that process being kicked off, I would tentatively say that a dismissal might be deemed to be unfair. Now, a lot of people are going to use the fact that we have to socially distance, they can't consult, all of those types of things as maybe a way to avoid consultation. I think that it will be something that we see going forward in litigation, whether or not that's going to be seen to be fair. If people consult, I don't think so. I think there'll still be a clear need to consult. So regardless of what is going on now, employers still have a responsibility to act fairly and in terms of what the Labor Relations Act tells us.
I hear what you're saying when you say consult. And people obviously using COVID as a reason not to be able to consult. But does consult mean we have to sit, or can they not call their employees, similar to almost how we're doing this Zoom thing, although this is not possible for everyone, or maybe even just have a conversation and let the people know, we understand that this is what we're doing, and we're thinking of when you spoke about categories, this is what we're looking at. So when people say consult, because like I said, some people just get a letter and say, we've thought about this and you guys got to go. Consultation is 0. So when you say consult, what can I expect as an employee when I have to consult?
So every employer is going to be different, and people are going to have to be innovative about the way in which they consult. People are going to WhatsApp, people will use Zoom, people will use email, people will phone. I think employers really need to be innovative. It cannot be this catch-all. There's COVID, we're locked down, it's dying.
Yeah.
So we're not going to consult. It can't be this, complete, ignorance of dealing with the issues in the way that they're supposed to be dealt with. And I don't think employers are going to be able to use it as an excuse later to say we ignored the procedural aspect of this dismissal just because we were in lockdown. We didn't care, or not that we didn't care, we couldn't. So I think employers are really going to have to learn to be innovative. A lot of employees are going to take their cases to the CCMA, and it will be for the employer to show that the way with their dismissal was fair, both procedurally and substantively.
I hope you guys got that the employer cannot just wake up and say, hey, we're dismissing and it is what it is, and they don't give you an opportunity to be able to actually even have a conversation, whether it's by WhatsApp, by SMS, by a phone call, by a Zoom. From what I hear Kgomotso saying is that the employer will need to show that they tried to actually be able to have these type of conversations with their employees. Kgomotso, we're still on you. Now, the UIF TERS, I know I'm gonna jump just now. With the UIF TERS, employers are saying, well, we can't pay you. That's why we can't keep you. That's why we're retrenching you. But a lot of the questions that came in from the link is that people are saying, but how can an employer say they can't pay me if the government made provision for them to be able to pay me?
So I'm going to defer part of this question to Jermaine, but just as what I'm, just at a high level, what we know is that TERS doesn't necessarily pay the entirety of an individual's salary. So it doesn't mean that that application, I mean, ideally people should get some of their money, but it doesn't mean that retrenchment will be completely avoidable, whether it's period now or in the next 6 months or 12 months. It doesn't mean that completely. But I would say that if a matter comes before the CCMA or the labor court, if an employer is saying, they're pleading poverty, they're saying the reason we dismiss is because of economic reasons, I think they're going to have to be able to show that they took certain measures to attempt retrenchment. So I don't think they're going to get away with having not even attempted to do a TERS application, not bothered to find ways to pay salaries, and then they now need to retrench. They did not all the avenues to retrenchment. So I think that is going to be going forward, but I think the rest should be deferred to Jermaine.
Yes, Jermaine, to bring you in here, following on what Kgomotso is saying, we have UIF saying that they've paid out over 9 billion rand in TERS funding. But a lot of employees are crying and saying that we haven't received the funds. And when people go on the link to check, some people can see that their claims have not been processed, but others can actually see that their claim has been processed, but they haven't yet received the funds. So when we talk about the space of retrenchments and employees and employers claiming poverty and not being able to pay, how valid is that as a reason for employers to then use that as an excuse as a reason to retrench?
No, that can't be a reason at all, because the government has expressly outlined lots of initiatives. Remember, this is an unprecedented thing that has never happened before. We are in the cusp now of history in the country and what the government is able to do. And I feel the government is actually bending backwards over to be able to mitigate some of those losses from the employer's point of view. There's so many funds available. Solidarity Fund, there is the Department of Trade and Industry, there's the IDC, there's all those places that they allocated money for them. And when it comes to the UIF, we've come to realize now and see that, look, but the employers are getting the money, but the money is not disbursed to the employees, of which now the Department of Labor has actually identified that. And the minister has expressly made a call stating that, look, guys, we're going to crack down on you if you're not going to pay this money. Some people think even this money is a loan. And I said, that can't be further from the truth. This is not a loan. This is a money that is allocated for you as an employee. So you can be able to access these funds. So
Jermaine?
another point also that I need to highlight is that UIF is not tax deductible at all. The amount of money that you see on your ID number is the amount that's supposed to get straight to you. Sometimes people see on their payslips that there's some money that was taken away out of this money, and that is not supposed to be. That is not a statutory deduction as to other deductions in terms of your payslip. So those things need to be cleared out, and they need to, the employees need to know that the money they see is the complete entire amount that was allocated directly for them. Yeah.
Jermaine, what could be some of the reasons why an employee doesn't get TERS? Because we've heard some people say, even in instances where an employer gets relief funding, we've seen where the commissioner has said that some employees are not declared. So what could be some of these other reasons that could leave employees? I know you're smiling, but there's a lot of things that are happening that shouldn't be happening. So from an employee, if I'm not receiving my TERS funding, what could some of those reasons be?
Look, I'm smiling because I've been speaking about UIF for years. On my YouTube channel, I spoke about when the amendments came to in 2016 about the UIF. I made an extensive video about that. Now, the employers are realizing now that, hey, we have not declared, we didn't care about this UIF. Now, the bomb has burst on top of you as an employer, of which now you have to, because in terms of the Unemployment Insurance Act, it says the employer must declare on the 7th of each and every month.
Yeah.
They have to declare electronically. And it's not so difficult to declare. You just, by a click of a button, then you've declared. Even if you have 10,000 people in your firm, by click of one button, the spreadsheet is available. You click the button, then if you declared. Now, when you as an employee go to the Department of Labor, I stop working now, which means now that I go to the Department of Labor, the official tells you, but your name is not here. What is this now? But I've been working for this company for 5 years now. My name is not here. Then start raising now. What happened in the HR? What happened to HR? Did nobody declare this person? What happened on all those levels? So which means that official now has to call the employer and say, look, send us UI-19 form, send us the all supporting documents, and the employer never bothered. So now the employer is becoming more vigilant now. They are getting to the bandwagon. Some employees haven't even registered their business. They've been operating for the longest time. They feel they do it now. So all these things are very unprecedented, man. And some of the reason that the money that they could not have received their money is because previously there was a claim, maybe an illness benefit claim. Maybe you exhaust all your sick leave. It goes into unpaid. Where do you go? You go to UIF. You claim illness benefits, or you go on maternity leave, and you claim that money. So now, when the COVID application comes, your application is somewhere stuck around in no man's land because of previous employment histories or employment periods that was never updated, or the termination of services was never indicated. So those are the type of teething problems that they have. But fortunately now the online system has come a long way. It had teething problems. I mean, I think U-filing has been around since 2006 already.
Yeah.
That's how long U-filing has never been used. Where we now, 2020, how many years has it already been on? Now that everybody's on the system, the challenge now is that the system is crashing all the time because of the influx, the volumes, they couldn't cope. I think I spoke to another guy working there. He said to me, look, they had to install a new server in their head office to be able to accommodate the influx. And I also heard that the Labor Minister, they have employed an addition to 250 people in the call center alone to be able to deal with it because they can't cope. That's the realities I have to indicate to the people, because they will be challenged. But it doesn't stop you from nonetheless as an employer to try to make your application go through. And there's many technical things I can go into it whilst the questions come as they arise, and then I will get into the details of that.
Yeah. So just to run down what Jermaine is saying, there could be many reasons, because that's a lot of the questions that came in from the link, where people were saying that my employer was paid and I can see that there's funds due to me, but they haven't been paid through. But the bigger problem is people who've been having their UIF deducted every single month. And they were under the belief that the employer was actually paying this money over to the UIF, but they weren't. So a lot of those employees are finding themselves in situations where they were not declared, which is also putting them in a bit of a difficult situation. But from what we're hearing from Jermaine is that the system is making it possible for employers to go and fix some of these problems. Just to declare the people and say, guys, hey, I messed up here. Can we fix the situation so that the worker who have been deducting UIF from every month can actually benefit from this TERS? But I must also stress here that with a lot of these things that are going on and everyone saying that it's unprecedented, a lot of times we also have to take the responsibility as employees and actually go and speak to our employers. You know, I've seen a lot of people sending me questions and I ask them, have you spoken to your employer? A lot of people have not even taken, maybe because of the dynamics between your relationship with your employer, but you must go and ask your employer what is going on. Even if it's a difficult conversation, it is important for you to understand what is going on, to understand what is wrong, so that you can understand how to take the situation forward. So thank you so much for that, Jermaine. We're definitely going to come back to this because it's a big one. Going back, Kgomotso, we got a very interesting question here. This actually threw me off because when we say a lot of things are happening that I don't think a lot of us could have even predicted. So the question that came in is that instead of retrenching employees, employers are opting to terminate permanent employment and switching employees to be on a contract basis. So the question is this the correct procedure? And should the remuneration stay the same? So I'm guessing here a situation where their long-term contract is, I guess, unilaterally, and they've been put on almost some sort of fixed-term contract. Kgomotso, could you please help one of our participants to get their head around this issue?
So it's oh, am I here?
Yeah.
I feel like somebody else is talking. Okay. So I think it's so difficult to say, is this the correct procedure? So because everything is so strange and unique, and maybe it's not fixed term contracts they're going to, but perhaps it's independent contracts that they're going to and trying to make their employees no longer employees. That might also be happening. So in any scenario, an employment scenario, if your employer wants to change the terms and conditions of your employment, that can't be a unilateral change. It has to be something that is between you and your employer. That again, the times are unprecedented. And I think a lot of employers are likely to ask employees to compromise, to do things they wouldn't have done, to ensure that they can keep something on the table. I think that's going to happen in a lot of cases. And a lot of employees are going to feel like they're under pressure to do that. And to be honest, a lot of the times they are under pressure to do that because it's between changing the nature of your contract and not having anything. So I think it's really, it's you know, we've gotten into a very unfortunate set of circumstances. But if an employee believes that their terms and conditions of employment have been changed unilaterally, which may even amount to a dismissal, the employee can still go to the CCMA and make a referral, either for an unfair dismissal or an unfair labor practice. But I mean, and I saw someone earlier in the comments, and maybe I should just quickly
yes, please,
saying that the law enforcement services are not operational. That's not correct. The CCMA is taking online referrals.
Yes.
It is very unfortunate that they're not taking walk-ins, but I think because of the reality of the, you know, trying to sort out social distancing and all of that. So right now the CCMA isn't taking walk-in referrals at all. People still have to do referrals online. Obviously that is a huge disadvantage to people who would not ordinarily do an online referral, but that is the way it is now, and you can still call in to ask for help, all of that. CCMA is operational. A large extent of their offices are going to be opening up on Monday, actually. So I think people should just pay, be cognizant that if there's anything that's happening to them during this time, they don't believe to be fair, they have every right to refer their matter to the CCMA, and it won't cost them anything.
I think that's very important for people to note that they are actually opening their offices next week. So for those of you who haven't been able to send in an online application, you'll be able to now. Pardon?
Let me clarify. Even next week, the referrals are still online.
Oh, the referrals are still online.
Yes. So processes will happen. Some processes will happen in the office. Not all. They will direct parties accordingly. But referrals are still online. That's very important.
Kgomotso, just tell our people which form should they use to refer this matter to the CCMA if they were going to do it online, and can they find it on the CCMA website?
Yes, it's on the CCMA website. It's called the 711 form, 7.11. That's the form used to make referrals to the CCMA. But you can also, if you are having trouble, if you look at the form and you think, what is this? What are they saying? Which happens to a lot of people, you can call into the call center to ask for assistance to help you fill out the form, which I advise people to do because, it's sometimes a little bit tricky. So people can make the referral using a 711 form. And this is really important, really, really important. Please do this if you are dismissed, for example, please make this referral within 30 days of you being notified that you are dismissed. 30 days you have. Otherwise, you have to apply for condemnation for filing your referral late. So 30 days is the magic number, or the most important number.
No, thank you so much for that, Kgomotso. So just to run it down, when your employer unilaterally changes your terms of employment, it means he cannot do it. Your employer cannot change the terms of your contract on their own without the both of you coming to an agreement. So with this question, when the one contract, the permanent contract, was terminated, it means that the employer almost sort of put you in a position where you almost didn't have a choice, because like Kgomotso said, it was either contract or unemployment. But that, she said, could almost be seen as a dismissal. So you can refer the matter to the CCMA and then see what comes out of that. Before we jump on to another UIF question, Kgomotso, I know you've written a little bit about this, but what does it mean to go on contract? Because, as employees who are on permanent employment, you have a lot of protections that you don't necessarily have if you were to be an independent contractor. So what would that mean? I mean, when you're making a desperate choice now to have employment versus being unemployed, what could the consequence of that decision be in the future for you?
Okay, so the difference between there are employees and there are independent contractors. The difficult thing is that those two categories sometimes are meshed up together, and a might believe themselves to be an employee, but they are actually an independent contractor, or whatever the case may be. Independent contractors fall outside of the protection of labor legislation. So, and even many of the COVID-19 benefits, for example, this UIF issue that we've been talking about, people who are not employees do not stand to benefit at all from that system. So, and even people who are not employees, who are independent contractors, when they have a dispute about what's going on with their contract, they cannot go to the CCMA. So there are pretty serious consequences to being an independent contractor. Reality, I mean, people assume that independent contractors are these rich people who have lots of money and they make lots of money all the time. And and usually now, because the world is changing, because is shrinking, because there's all these issues that we have economically, lots of business switching to independent contractors to avoid things like IF, to avoid their employees being protected under certain types of labor legislation. There's even implications in relation to COIDA, which protects people against occupational health and safety issues. A person who's not an employee does not fall under that protection. So there are quite serious consequences, but the challenge is, and the reality is, that many businesses are going to opt for these independent contracts in an effort to, you know, minimize their
Costs.
expenses,
Yeah.
minimize some of their costs, minimize some of their responsibility. And really, yeah, so there's a lot of challenges in the sense that lots of businesses are going to move this direction, probably over the next 18 to 24 months.
I think that's important for us to take away with us, that if you're presented with a contract that is very different from the one you originally signed, which was a permanent contract, just take your time before you make that decision. I mean, we understand it's not easy to tell someone to take their time when they might be facing unemployment. But even if that was to be the case, you need to remember that there's remedies where you can even go to the CCMA, because then if you don't accept and they say you are dismissed, then that will probably be akin to an unfair dismissal. So remember that. I think something that we forget as employees is that we're very protected. The labor laws in this country actually do favor employees to a large extent. So just think through some of the decisions that you're making and what they could mean for you going forward.
Can I just jump in one last point? I know there's probably some people who are on this panel who are actually employers, and some employers who represent employers.
Yeah.
Please should actually go to them.
Yeah.
People who are employers and who represent people who are employers, you need to engage your employees in the correct way. And employers have so much power in this scenario, so many decisions that affect employees' lives. Consultation is so important.
And I think also from an employer's point of view, you don't want to catch yourself on the wrong end of the consultation when you're sitting at the CCMA because you failed to make the proper consultations or to just follow the proper procedures. There's a burning issue here when it comes to retrenchment. Jermaine, we're going to come to you just now. The famous last in, first out. That seems to be what everybody's talking about. Like, if I was the last person to join the company, does it automatically mean that when retrenchments start to come in, am I the first one out? Is that how it works?
Okay, so last and first out is one type of selection criteria. So when an employer is trying to decide, okay, I'm thinking about retrenching, the employer needs to come up with what their selection criteria is. How do we decide who should be retrenched and who shouldn't be retrenched? That selection criteria is not fixed. Last and first out is one of them. It means that the people employed now are the first people who are retrenched, saving the jobs of people there for 10 years, right? The only criteria. And oftentimes employers will say, the oldest people who are here, because they're so very close to retirement, let them take retirement. The employer might offer voluntary retrenchment packages to say, if you volunteer to be retrenched, this is what this package will look like. That's happening quite often now. The employer might say, these 5 employees are very expensive and they're not bringing a return, a reasonable return into the business. They're costing us more than they're making. Those are the types of people we need to consider. So selection criteria can be very different in every retrenchment. Last and first out is just one selection criteria possibility that an employer can use.
Thank you so much for that. And also just to latch on to what Kgomotso said, Jermaine, I'm going to bring you in here. Now, the situation obviously would be different once you've been retrenched. Would you still fall under TERS